appeal in the matter of Qasim and evidence made for
So, Mr. Gill, we have received a note on the question of anonymity, which we have read, but the court's decision remains that there will be no anonymity granted to the appellant in this case. So far as the appellant's wife and children are concerned, we see no need to refer to them by name at all, nor even by letters. They can simply be referred to as wife and children. Their identities are completely immaterial. So that deals with the question of anonymity. The next matter to address is the applications by each side to adduce further evidence. At present, unless there's any objection either way, we are minded to grant both applications and to admit the further evidence that's now being sought to be put before the court. Is that all right? Very good. Thank you. That then takes us on to the substantive appeal. And so far as that is concerned, it may be helpful if I make this observation to start with. We have all read the FTT decision, the UT decision, and the skeleton arguments of the appeal. We are a little unclear at the moment as to why the appeal has been listed for 2 days, given that it was estimated at 1 day when Lord Justice Lewis granted permission to appeal. However, given that we have a 2-day slot, you're under no time pressure.
Well, Lord, I'm grateful. There are, as things stand, 2 grounds, ground 1A and ground 2. Your Lordships, my lady, you have them. I'm not going to recite them. I'm just going to fit straight into ground 1 and make my ground 1A and make my submissions on it. We say that in relation to ground 1A, that the FTT either had no jurisdiction or it exceeded its jurisdiction in taking the appellant's evidence by video link from Pakistan. That's the first main submission. There are 3 main submissions. That's the first. The second is the respondent failed to disclose to appellants and to courts, by which I mean tribunals as well, the existence and nature of her policy of presuming consent from a bare informal notification of an intention to carry out video link hearings. And that failure tainted the fairness and legality of the FTT's process. And thirdly, the respondent improperly liaised with the president of the FTT to obtain advice as to the evidence that would be acceptable to the FTT, no doubt as a whole, as evidence that lawful attempts have been made to obtain permission of the foreign state. On each or all of those bases, we say that there was a fundamental illegality in the way in which the FTT process worked. In relation to the second and third limbs of the submission, we say that if these matters had been disclosed, the appellant would have been able to make submissions on them and would have been able to say more as to why the process was unlawful. that opportunity was denied, and applying the cases that have been set out in Underground 1A, which I'll refer you to briefly, but in this case an argument, we say this means the process needs to go back for a rehearing. That's essentially the argument in relation to Ground 1A. So far as the first of those three basic points is concerned, the primary submission in relation to the first of those, the primary point, I suppose, in relation to the first of those, is that the courts cannot permit a situation where they have unwittingly violated the territorial sovereignty of another state. All the more so where they've been misled into that situation. It's as straightforward as that. They cannot allow themselves to engage in a process where the territorial sovereignty of the foreign state in question has been violated, which it plainly has.
Well, I'm a little puzzled by that way of putting it, and maybe you can enlighten me, not necessarily immediately in response to my question, but in the course of your submissions, because the way you formulated the submission at the outset was that the FTT had no jurisdiction or exceeded its jurisdiction in taking video evidence from Pakistan. Now, thus formulated, that presents a fairly clear ground of appeal, but it would seem to involve an inquiry into what is the source of jurisdiction under English law, and in particular English procedural law, whereas you seem to have just invoked notions of sovereignty, which appear to be in the realm of diplomatic relations. And I'm a little puzzled at the moment as to see what diplomatic relations have got to do with English procedural law.
I don't think they have. The point is that it is not a question of diplomatic relations at all, which is the way in which the Secretary of State puts it. Of course, there is going to be diplomatic communications, but that's not the point. That's just the mechanism by which agreements are reached.
But I don't quite understand the jurisdiction point for a moment. Is it Section 82? Section 82 says the tribunal can hear an appeal against a refusal of a human rights claim, which this was. And they heard an appeal against a human rights claim. It may be the Secretary of State has not had an adequate policy about how she ensures that evidence can properly be provided from a state which objects. And we don't know whether Pakistan does or doesn't object at the moment. We've got the latest note from August saying they want a bilateral treaty. But what is it that means that they have no jurisdiction to hear an appeal if in the course of it they hear some evidence that comes to them by a route that it shouldn't have come to them?
I think the short and simple answer is that the jurisdiction is limited to the territory of the United Kingdom. If it is to be said that they can take evidence, that they want to take evidence, that they should take evidence from abroad, that involves a invasion of the territorial sovereignty of the foreign state. I don't think there's any dispute about that, but we can look at.
But it may. It depends on whether the other state objects.
Well, on the face of it, there is a violation of the sovereign territory of the other state. In order to ensure that that violation does not occur, the relevant court or tribunal must make sure that it is not bringing about a breach of that principle of territorial sovereignty, and it must ensure that the permission of the foreign state has been requested and obtained.
Right. But if they don't do that, they should have done it and they didn't do it. But the evidence is in front of them. And you can get evidence from lots of different sources, actually, that shouldn't be there. You have it in criminal trials where they breach principles of domestic law. So why does this piece of evidence being received when, on your analysis, it shouldn't have been received without checking with Pakistan? Why does that render the hearing unfair? The hearing is into the claim, which involves the evidence of the appellant, his wife, the social worker, and others. All that evidence has gone before them. Why does it render that whole hearing unfair?
I say it renders it unlawful.
Unlawful.
As well as unfair. It's a question of legality. Because what has happened is that the court has been pulled into a situation where it has been led into taking this evidence from abroad, and it has been led into that situation without the relevant tests being satisfied. Moreover, the court has been misled into that situation.
Well, they weren't
slightly
actually. They were
different
told exactly what the position was in a witness statement. It's not so much that it's not like Yilmaz, where, quite shockingly, the Home Secretary didn't tell the court that she'd been told 6 weeks earlier that Turkey had objected because they were going to have another go at persuading them, and they were rightly criticised for that. In this case, at page 320 of the bundle, the position was set out. Whether it's adequate, whether they should have done more, whether that's enough, is another question. But they were told in a witness statement, and the documents are exhibited, that the lawyers in Pakistan had said there's no restriction in Pakistani law on the giving of evidence via video link, and the High Commission in London had been told, but had not replied. And that's what the tribunal were told. So they knew what the position was, they knew that nothing more had been sought, and they proceeded on that basis.
Well, we'll come on to the evidence in a moment, but dealing with the point you're asking me to deal with in the context of the primary submission before we deal with the misleading, the point here is that the tribunal should then have asked itself, does this comply with the obligation to request and to obtain the permission of the foreign state? And if it doesn't, what do we then do about it? They never did that.
Well, firstly, you need to show us where this obligation comes from. You referred to it, but you haven't shown us where it comes from. And secondly, even assuming that they should have checked more rather than it being the responsibility of the parties, what happens when a tribunal does something and hears evidence that they shouldn't have, but they've got the evidence now? Why does that make the decision?
Well, that's clearly
two questions there,
that's clearly concerning you. So whilst we're dealing with all things else more or less in one go, let me just try and...
We should allow you to develop your
Yeah.
submissions, but I think we would find it helpful if you could begin with the sources of jurisdiction.
Yeah. But if I can just give you an indication of where I may be headed on that point, it is not that the appellant wants to give evidence by video link. It is the fact that in order to have a lawful, fair and effective hearing, the Secretary of State needs to ensure that there is an effective and lawful video link hearing from abroad. It is the Secretary of State who therefore has to get this process in place. That is, Jarin bin Nosra, I'll take it that in a moment. That is the appellant's position at all stages was, you can't take this evidence from abroad. the burden is on you to show, you the Secretary of State, to show that you've got, if this is going to happen, that you're going to be able to do it lawfully, fairly, and effectively. That was made clear to them even as early as September 2017 in the first CMR that I attended. And I've given cross-references in the skeleton argument to that. That being the position, the tribunal and the Secretary of State had to start from the default position. But the default position is that you have in-country appeals. It is a second best to have a video link for the reasons explained by Lord Wilson and Karen Windloss. It might be satisfactory in an appropriate case or not. That would depend on the situation. But where the appellant says, no, I need to be in a position to attend because you're going to assess what sort of person I am and you're going to assess what is the current state of my relationship with my children and so on, that attendance and giving of oral evidence in person therefore becomes of critical importance. That's recognized. So that being the primary position from which a jurisprudence has developed along the AJ lines and so on, that one could accommodate that in some circumstances, and where there is a need for oral evidence, it might be possible to hold it by video link. That being the position, the appellant's position, an unfairness arose to the appellant, even if we are in the realm of unfairness, which I say we're not, we're in the realm of legality. An unfairness arose to the appellant because the Secretary of State failed to make even the request to Pakistan and failed to obtain the permission. But that's, I hope, an indication of where I'm going with that. But to deal with the starting point, we say is, I can't see that there could possibly be any dispute about it, that the territorial extent of the UK courts and tribunals extends to the United Kingdom.
Well, these questions are always context dependent. So let us say, for example, that an English court is enforcing a contract. That can be enforced on a worldwide basis. There's no difficulty with that, it's done all the time. So submissions that UK courts don't have jurisdiction outside their own territory are empty unless you identify the context.
Yes, yes. My Lord, I acknowledge that, but I say that's the starting point. So then one sees what the context is and does it change from that?
So in the present case, we're concerned with the statutory jurisdiction, are we not?
We are.
So might it not help to start with the statute?
My Lord, so far as the statute is concerned, there is nothing in this in the 2002 Act. So far as the Tribunals, Courts and Enforcement Act is concerned.
Well, you say there's nothing in the 2002 Act, but can you help me on this? My Lord Justice Lewis has pointed out that we are concerned with an appeal under Section 82.
Yeah.
That's right, isn't it?
Yes, yes. I'm sorry. Clearly, it's Section 82 is, in that sense, the starting point. What I mean is, it doesn't really say any more than the fact that you can appeal.
Then you've got Section 92, which tells you where the appeal may be brought from.
Yeah.
Not where all the evidence is coming from,
True.
but where the appeal may be brought from. And Parliament has said that the appeal doesn't have to be brought from within the United Kingdom.
That's true.
The appeal can be brought from outside the United Kingdom. So the suggestion that the jurisdiction is limited to the territory of the United Kingdom can't mean only if the appeal is brought within the United Kingdom, because you'd be telling us to disobey Parliament. So there must be more to it than that, Mr. Gill.
you're quite right. I'm not, that much is so, but I don't think that helps us answer the question in the particular case. But that's fair enough. And I've put those in the authorities bundle, and you've seen those. Beyond that, there's nothing else. So far as the Tribunals, Courts and Enforcement Act is concerned, there is section 147, which is at page 38 of the authorities bundle, tab, it's at the end of tab 2, I think, page 38. And it says no more than what it says, that the powers of the tribunal, parts 1, 2 and 6, extend to England, Wales, Scotland and Northern Ireland. Now, that is as far as it goes. There was a provision inserted in 29ZA during the course of the pandemic, which is at page 40 of the authorities bundle, tab 3, if there are tabs in your bundles, which there may not be. But that was only for the period of the, in effect, if I can put it in shorthand, the pandemic. And that did, we see from page 42. But that is specifically, I think, relating to, well, what it's saying is that the FTO of the tribunal directs that the tribunal proceedings are conducted wholly as video proceedings, that the tribunal may direct that process to be broadcast, etc., etc.
So that's concerned with making the proceedings public,
That's right.
as opposed to receiving evidence.
That's right. So that's all that there is. So far as the actual First Tier Tribunal rules are concerned, at page 738 of tab 40, there is simply, and this was referred to in Chiari and Bindloss, you'll see that on page 740, it says that the hearing means an oral hearing and includes a hearing conducted in whole or in part by video link. It's about 2 or 3 inches down from the top of page 740. And so they contemplate that you may in part have to have hearings by video link. But beyond that, and then it's Rule 14, but unfortunately Rule 14 isn't here. Rule 14 then talks about hearings, so that's what this links to, but Rule 14 doesn't say any more. It's referred to in the Supreme Court's judgment in Chiari and Bindloss anyway. So it doesn't tell us about how you actually go about the process of taking video link evidence from abroad. On that basis, it could be said, which is why this point was put in the limited way that it was in the skeleton argument, that it may be that this court wishes to consider whether it's got jurisdiction at all to receive evidence from abroad. It may be that the court says, well, that is perhaps sufficient to say that one can, in principle at least, take evidence in a case from abroad. We say that's not enough. What should happen is that there should be a specific statutory provision permitting this evidence to be taken from abroad, and that isn't there.
So there's no power for the tribunal, even if the other state agreed and said, yes, we have no problems with that. The absence of a statutory provision allowing the First Tier Tribunal to receive evidence via video link from a consenting country, there's no power for them to receive it.
That would be the effect of what I'm saying.
That's what I want to know. Is that your submission?
That would be the
effect. It has to be a statutory power, and there is no statutory power, so they could never receive any evidence from abroad.
Yes. Now, you'll note the way in which it was put in the skeleton argument. I recognise that there are counter arguments to this point as well. or a process in the rules. The process.
Sorry, I'm a little puzzled, and maybe I'm missing the point. You've just drawn to our attention the fact that the FTT rules expressly contemplate a hearing conducted in whole or in part by video link. Now, let's start with the position that the video link is within the United Kingdom. Is it your submission that, notwithstanding the fact that the rules expressly contemplate a hearing in whole or in part by video, that there is a deficit of jurisdiction to allow that to happen?
No.
Right. So where is the deficit of jurisdiction if the hearing is in part from a foreign territory?
Although there are two ways of putting it, and the first is not my primary way, it's the second, but the first is this. There is no process directly equivalent to the CPR regime that we've referred to in the documents in the FTT. Even the county court, when it has to take proceedings from video link evidence from abroad or evidence from abroad, and it has to issue letters of request, can't actually go about that process itself, but it has to ask the assistance of the High Court. I'll show you the CPR rules in a moment about that. So we say the first way is, the first point is that there is no such mechanism in the FTT context. Now, it could be said against me, and I recognize this. Well, actually, whilst the First Tier Tribunal rules contemplate the possibility that there could be a video link, they don't limit it to necessarily video links only within the country. So what the tribunal has to do is to then to devise a mechanism for itself akin to the CPR, and it would be said against this first part of my submission, is that the tribunal have in fact done something like that.
You've got to separate out what you said about jurisdiction, power, and have they got a practical machinery in place to enable that to be achieved. In terms of jurisdiction, don't forget, Parliament has said that certain appeals have to be brought from outside. So Parliament is contemplating that something is going to start off outside the United Kingdom, the appeal. If the person doesn't want to give evidence, there's no problem. If the person wants to give evidence, then the question is, do they have power? But the combination of Section 92 and the rules must surely mean that the power, the jurisdiction to receive evidence is implicit.
My lord, my lady, you'll note the way in which I put it in the skeleton argument, that this is a point the court may wish to clarify and to consider. I recognize the strength of what my lord is saying, but I thought it appropriate to raise the matter so that you could actually say something about it. But my main point about jurisdiction, which is the second point, is this, that assuming that by a combination of those provisions that we've just looked at, it is said that, well, the appeal can not only be brought from abroad, but it is possible for video link evidence in theory to be taken from abroad. If we get to that position, the question on jurisdiction then that arises is, does in a particular case the tribunal have jurisdiction to take the evidence from abroad? And that depends.
Why can it depend on the specifics of a particular case? I'm puzzled by that. I mean, either the FTT has jurisdiction to receive video evidence from abroad or it doesn't? How can it depend upon the specifics of the case?
My lord, it can depend on the specifics of the case in this way. In order to be able to take video link evidence from abroad, one has to obtain the permission of the foreign state. That is a rule not only we say of international law, but Mr. Kovac says, well, there's some lack of clarity about that. He's not conceding that, but it's certainly a rule of national law.
Okay, well, where do we get that from?
We get it from the most directly in our context from NARE and from the presidential guidance in 2013, which I'll take you to in a moment. But that is built upon and takes its inspiration from the approach in the CPR. Because what the courts have done through those mechanisms is to say that if we're to receive evidence from abroad by video link, certain processes will need to be put in place. Why is that? The reason for that is that we recognize that it will be an invasion of the foreign state's territorial sovereignty, even cyberspace sovereignty, which is a phrase which is becoming more and more used in this context. And we can't allow ourselves to be pulled into that situation unless we're satisfied.
But is it jurisdictional? Say the court failed to comply with the requirements in the CPR. Does that mean that the entire proceedings are in some way wrongful and should be set aside on appeal?
Well, my lord, I'll try and get the passage for you in a moment, but in the Norway case, the House of Lords said that...
Before looking at that, could we start with the CPR? Because
yes,
you've twice placed reliance upon the CPR, and I think we would find it helpful if you could show us the passages in the CPR that you're relying upon, which you're saying, as I understand it, should be applied by analogy in the present context.
Yes, let me go through that, but without turning up the... if I can just answer Lord Justice Lewis's point in relation to this. In that case, Lord Gough said, well, I don't know whether I want to put it in terms of lack of jurisdiction or excess of jurisdiction. It doesn't really matter. He sort of left it to one side in that way. But we'll come back to that.
Yes, indeed. Yes. Please, I'm not, don't misunderstand me, I'm not deterring you from coming back to it. I just want to go in a logical order.
Yes. So far as the CPR is concerned, the CPR, which is at page 46 of the bundle.
Yep.
Rule 32.3.
Right, so that's entirely permissive.
That's right. And the footnotes, there are quite a lot of footnotes, but and I hesitate to...
Sorry, maybe I didn't make myself sufficiently clear in what I just said. Rule 32.3 says that the court may allow a witness to give evidence through video link or by other means. Now, we can see that that is entirely permissive. That is to say, it's an open-ended jurisdiction. There is no limitation upon that jurisdiction.
I agree.
So in what way do you say that the jurisdiction is limited?
Well, I'm just drawing your attention to the relevant parts. That's the first part. So far as the footnotes are concerned, I won't take time over them, but you may want to look at them in due course. At 34.13, which is at page 50 of the bundle, it says this rule applies where a party wishes to take a deposition of a person from who is out of the UK. And it then sets out a process for doing that.
Yeah, well, that's taking a deposition abroad pursuant to a letter of request. What's that got to do with our situation?
This is the process built in effect upon the procedure devised in the Hague Evidence Convention, and 34.13a on page 53 talks in similar terms. Now, there is also in...
Hold on a moment. This is about a person from England or Wales going to the foreign country, isn't it? To be in that foreign country, to examine the person or to take a deposition and so on. That's what this is about, isn't it?
Well, at 34.13.5, a person may be examined under this rule on oath or affirmation or in accordance with any procedure permitted in the country in which the examination will take place. And so I think the depositions could in fact be taken in more than one way.
Oh, to be sure.
Yeah.
But this is about invoking machinery in the foreign state. And in particular, the whole point of this is that it's common under this practice where you have the possibility, and it doesn't always exist, of compulsion using the machinery of the foreign state, that you ask the foreign state to do that. Now, of course, that gives rise to very real questions of sovereignty. But it's all about the courts of this country asking the courts of the foreign state to exercise the machinery of the foreign state to obtain evidence for use in this country. But in our scenario, we're not concerned with any request for use of the machinery of the foreign state, are we?
We are concerned with a request to the foreign state to allow evidence to be given from that foreign state to a UK court or tribunal, and that I say inevitably involves the UK court or judge who stands in the place of the Crown, in effect saying, I want to examine, or it is necessary for the purpose of these proceedings to examine somebody abroad.
Can you explain to me how that arises? Suppose I make a telephone call to a friend who is resident in Pakistan. Does that invoke the machinery of the state of Pakistan?
If you're a private person, no.
So I do a video link by Zoom with someone in Pakistan. Does that invoke the machinery of the state of Pakistan?
In the way in which your lordship has put it, if you're a private person and you're just that doesn't.
So what's different about the present case, where what is being done is simply receiving the evidence of a private individual through a Zoom link?
This is a situation where the Crown, through one of its judges, is seeking to perform a act of English sovereignty, which is to receive evidence.
What actually happened here was that he went to the British High Commission in Islamabad, as I understood. Isn't that what happened? And he gave evidence. I'm not saying it makes any difference, because the High Commission is still within Pakistan, but where did he give his evidence from then? Where was he at the time that he gave his evidence?
It wouldn't make any difference to my argument.
So where was it?
But he was at a visa application centre run by a private entity with whom the respondent had an arrangement, and private facilities internet facilities were therefore used. Hardware was provided by the Home Office.
So it wasn't through the embassy then?
No. And my point would remain. I mean, I can't reopen Johnson. You've given a decision on that, and we are where we are. But the position is that where a judicial act is taking place in this country, and it is seeking to take evidence from a foreign state, you can't do that unless you get the permission of the foreign state. That's the point, because it's an assertion of judicial. English judicial sovereignty or English sovereignty over the sovereignty of the other state. You need to get their consent.
Well, but why as a matter of English law? Because, I mean, let me give a different scenario. An English court decides an issue of foreign law. Happens all the time in our courts. Is that an exercise of sovereignty? Do we require the consent of foreign states to decide issues under their law?
My lord, that with respect is a wholly different question. It has no bearing at all on what we're discussing. As your lordship knows better than me, that in that situation, the English courts have developed a rule saying we will decide this simply as a question of fact as to what that foreign law is, and we will receive expert evidence in relation to it. That's all. That's all they can do.
What about where English courts grant anti-suit injunctions? Which again is something that post-Brexit we're starting to do with increasing frequency again. Of course, it was common prior to certain rulings of the Court of Justice. And the typical scenario is where there's an exclusive jurisdiction clause in favour of the English courts. Proceedings are commenced in a foreign court in breach of that, and we issue an anti-suit injunction to require those proceedings in the foreign court to be discontinued.
My lord, those sort of contexts generally involve, and again your lordship will know more about that than myself, but generally involve certain international regulatory regimes. They take place in the context...
No, it's common law. It's all common law. The whole point is that we're free of the international regime constituted by the EU, which enables us to go back to what we did under the common law.
Well, my lord, in those contexts where it is solely common law and that there is no relevant international framework operating, such as some convention, etc. In those contexts, all the court is doing is making a decision which may or may not ultimately end up being capable of being enforced. Depends what the foreign state may have to say.
Indeed, but my point about asking these questions is that what they demonstrate, I would suggest, is the mere fact that what an English court is doing has some impact in another state can't be regarded as objectionable per se.
It is if you do not do the basic inquiry which your own English processes require you to have carried out.
So fine, then you rely there upon the English processes, and we therefore need to identify the relevant English processes. Now, you've just taken us to CPR Rule 34.13, which is inapplicable, and I'm wondering what else in the CPR that you're relying on.
Well, my lord, at page 54,
Yep.
there is, this is the family procedure rules. It says at the top, Practice Direction 22A written evidence, Annex 3, Para 5. There is, in fact, a similar provision like this in the Practice Direction to CPR 32.
Indeed, there is, yeah.
And you will see at the top of 55 what it says, that it should not be presumed that all foreign states are willing.
But we're dealing with jurisdiction here. We're working on the hypothesis for the moment that Parliament has contemplated appeals from outside England. We're looking at a power that allows video evidence. And the question is whether there is a provision which says you must have consent before the video evidence is received, because if you don't, the power to hear that evidence doesn't exist, and furthermore, the whole appeal is, you say, unlawful. And you're still not answering with respect to the question of where is the limit on the jurisdiction, the ability to hear an appeal and hear evidence, as distinct from they didn't get it right here, they didn't get all the consents in order, but it's happened. That might mean the evidence wasn't obtained in a proper fashion, but that doesn't mean they can't receive it. or have regard to it. It's like criminal cases. The police, I don't say often, but it happens that the police break the relevant rules. And the courts then have to decide, are they going to have regard to the evidence or not? And simply because it's the case, whether or not it's international law or Pakistani law, but you haven't showed us either, there's a prohibition on it, doesn't mean that it's a matter of English law. The entire appeal is null and void, and the taking of evidence is not only irregular, but illegal, because it may be irregular without being illegal.
Well, the second way in which you've expressed it, we'll just put to one side because we're focusing on the first, which is what you're asking me about. What I say is that this sort of value, this sort of principle, that is at the top of page 55, this idea that it should not be presumed, etc., and that the party who is directed to be responsible for arranging it will be required to make all necessary inquiries about this, etc. This sort of idea has a certain basis to it. But let me just take you to the passages, because I want to be careful that I don't slow down too much, and then come back to try to answering the point that you're trying to press me on. In relation to what the tribunal did in the case of Nare, which is in the authorities bundle at 629, tab 32, and there the tribunal in 2013, 2011 referred in paragraph 17 to CPR. They adapted that sort of practice to the guidance they gave.
Can I just see what Nare was all about, actually, before we get into a paragraph? So, was this an appeal from abroad or not?
No. What happened?
Just in England?
Yeah, what happened here was the person had given evidence. Appellant had been allowed to give evidence from his phone, and I think that it was within England, and it was a sister, in fact. But the tribunal took the opportunity to give some general guidance
As to when it should be in court rather than by some means in England outside court, in this case from his phone, wherever he was when he called it. And they're worried about things like giving oaths and not being prompted and so on. Is that what this is concerned with?
Yes, but a bit more than that. At paragraph 21, it deals with those sort of matters, and it then says that D, on page 635, if the proposal is to give evidence from abroad, the party seeking permission must be in a position to inform the tribunal that the relevant foreign government raises no objection to live evidence being given, etc. And you see the rest of it.
Well, that guidance, A, it's obiter dictum, and B, it says if the foreign government raises no objection.
Yeah.
That's a bit different. That's what they were doing. They were sending it to Pakistan and they weren't raising any objection, and that was it.
Well,
but no, it's not seen as enough.
Well, this was then followed by next page, 637, the guidance note from the president, and again at paragraph 13, 639, 14, it should not be presumed that all foreign willing, etc. Third line, if there is any doubt, the party making...
So where are you reading from?
Bottom of page 639.
14, yeah.
Paragraph 14, sorry.
But I'm a bit puzzled by this, because what you're relying upon here, and one sees it from Nare, it's inspired by the paragraph in the annex from the CPR, is that this is all guidance to tribunals as to how they should operate. and it's quite clearly intended to ensure that there is no diplomatic difficulty caused by a tribunal in this country. But where in any of this guidance do we find any limitation upon jurisdiction?
The primary point that we were discussing about jurisdiction, I've made my submissions on that. The other way in which I was putting it in relation to that at the very outset of my submissions is that the jurisdiction isn't going to be there if you haven't carried out a necessary prerequisite.
But I'm puzzled by that. Look at paragraph 14, which you were just relying upon. It says, if there's any doubt, the party making the application should make appropriate inquiries with the FCO with a view to ensuring that no objection will be taken at diplomatic level. So that's what the guidance is about. It's trying to ensure that there's no objection at diplomatic level. Where is the limitation on jurisdiction?
Question arises then, why is the guidance doing that, and why is the CPR doing that?
Because there might be an objection at diplomatic level.
And why might there be an objection?
Because the law of Pakistan might prohibit it.
It may be more than that. It may that would be maybe one reason. It may be that Pakistan takes the view that you are carrying out what is in effect an English sovereign act in assertion of English sovereignty, and we can't permit that on our side unless you get our permission.
It could be a breach of the foreign state's domestic law, criminal law, civil. It may or may not, but you haven't shown us anything yet, be a breach of a principle of international law. If so, where is that principle enforced? Or it could be a breach of domestic law to do that. So far, we're only looking at domestic law, and so far you haven't shown us any provision that says it will be outside the jurisdiction, or it will be illegal or unlawful. What you've shown us is guidance indicating certain consequences that might follow. And what I'm still looking for is a clear statement of jurisdiction as opposed to desirability.
My lord, I'll take you to what there is, but it is right to say that there is some people take a different view on this to the view in which I've expressed, but it is also the case that the general view and practice appears to be, so far as one can tell from the two cases that I'll take you to in a moment, that it is, this sort of conduct is an impingement on the sovereignty of the other state. And it is for that fundamental reason that you've got to make these inquiries, which are of course done through diplomatic channels, inevitably, to see whether there is any objection to this invasion of sovereignty in effect. The two cases that I wanted to draw attention to is the Norway case and the interdigital case. I say it's not for me, however, to show this. It is for the respondent to show why.
No, because you're saying it is unlawful. You're saying if they haven't shown certain consents have been given, the proceedings are unlawful. You need to show us what provision makes it.
Yeah,
I'm not saying what they did was desirable. They know the views of this court, but the way they've gone about things. But this is a different question. It's for you to show, because you're saying two things. One, it was unfair. Why? And then two, it was more than unfair. It was illegal. It was a breach of a principle of domestic English and Welsh law. That's where we are at the moment.
So, shall we look at Norway then? That's page 120.
That's right. Now, this is a case in which Norway authorities asked for the assistance of the English courts. Issues of sovereignty in this regard were raised, and the sovereignty is mentioned at many places in this, but and I won't just a word search for sovereignty will reveal it, but leaving that to one side, for instance, at page 130, the primary contention was, at middle of letter C, since the proceedings were concerned with a state's assessment to tax in Norway, compliance with the by an English
All right,
court.
but that's in the Court of Appeal.
Yeah, yes.
That's right.
So we need to look at what the House of Lords has to say.
Indeed. The House of Lords relevant at page 187
Yeah.
is where Lord Gough's judgment starts. What he does is he looks at the history of the 1970 Act. He then says at
Perhaps you could just take us to the statement of principle that you're relying upon.
yes. Having set out the history over several pages, he then, at the bottom of page 204, begins to deal with certain ideas of jurisdiction which may not directly apply directly to this case, but at the bottom he notes the point that from Lord Denning, that by international law every sovereign state has no sovereignty beyond its own frontiers.
Yeah, but one has to look at the context. The context here is enforcing penal or revenue or public laws of the foreign state.
That's right. So that, but the principle is important. Of the next page, 808, in the middle, again, whether that enforcement, direct or indirect, of foreign revenue laws would constitute an invasion of the sovereignty of this country. Now you could, from there, and then he explains that further on that page.
I mean, this seems to say that there was jurisdiction, and the next question is, should they exercise it or not, and help the Norwegians?
Yeah, there is a passage which I can't immediately put my finger on, where he says, well, I'm not going to, it may not matter much whether it's excessive jurisdiction or want of jurisdiction, and it may be that it's an excessive jurisdiction, that they had jurisdiction, but they acted in a way that they should not have done. But what this is indicating is that there is a sovereignty backcloth to this. It is, I say, and I've said it already, that in seeking to take evidence from abroad, what a court is really doing, whether it's doing it by way of taking depositions, whether it's doing it by way of taking oral evidence.
Sorry, I'm baffled. I do apologise for interrupting you when you're in mid-flow, but you were just referring us to page 808 of the report, 205 in the bund. And I think you referred to the paragraph that starts at letter E. And at the moment, I'm struggling to see how you rely upon that, because if we go down to just below E, what Lord Gough says is, I do not see how such letters of request or their execution could amount to the enforcement, direct or indirect, of a foreign revenue law, nor do I see how they could constitute an invasion of this country's sovereignty.
Yeah, what he says...
So he seems to be saying something that's flat contrary to your argument.
Well, what he says is, such a conclusion is, in my opinion, acceptable once it is recognized that the rule does not affect the jurisdiction of the court, but is concerned rather with the circumstances in which the court declines to exercise its jurisdiction. So that's the passage that I was drawing attention to, that what he's saying is this isn't really necessarily a jurisdictional question.
No, it's a manner It's whether or not you should exercise it. And indeed, as I understand it, having quickly read to the end of the judgment, they did allow it. And they restored the judge's order below so that the taxpayers could be questioned in England, or I might have misread it. It seems there was jurisdiction. It's all to do with the manner of the exercise of jurisdiction, and they did allow the exercise of jurisdiction here. Is that right?
Yes. The point that I'm trying to make is that whilst in going back to the discussion we had at the start, that there may be that there is a jurisdiction in principle to receive evidence. But the question that arises is, how do you then exercise that jurisdiction? And then does it really matter as to whether you characterize the exercise of that jurisdiction as an excessive jurisdiction or as something else? Let me put it a little bit more directly and simply than that. If you haven't got something, a prerequisite that you should have before you decide to do something, it may be said that that something lacks a basis for it. It may be that that is put in terms of jurisdictional terms, or
it could be a precondition to the existence or exercise of power that a certain state of affairs exists.
Yeah.
Or there could be jurisdiction. There may be rules governing how evidence is got, and if the evidence is got in a way that doesn't comply with that, then it's a matter for the discretion of the tribunal. But even assuming for the moment it's the latter, and even assuming the United Kingdom government did not do what it should have done, or the tribunal failed to do checks, if it's just the manner of exercise of jurisdiction, they get things wrong, that wouldn't necessarily mean that the whole proceedings are unlawful and that you should disregard the evidence that this appellant gave. He's not giving it under compulsion. There's nothing like that. He gave it because he wanted to give evidence and had been told to leave the country, and he wanted, obviously, to try and get back. So there's no element of compulsion there. He does it even if there's been a failure at whatever level, domestic law in Pakistan, international law. If this is a manner of exercise, it's down to whether or not the court should exclude his evidence. It wouldn't affect the appeal. It's in his interest to have the evidence there.
Not in the way that it was. We objected strongly to this. We said we only give this evidence under protest. We've said all along.
He wanted to give evidence. He'd like to have given it in this country, but he couldn't give it in this country at the time. So he gave it abroad. He wanted to give evidence. There's no suggestion that he was not giving the evidence he wanted to give. So the only question is, does the manner in which it was given, assuming it involves some breach of a Pakistani or international rule of law, mean that the tribunal should in some way disregard his evidence? And then if they have to disregard his evidence, does that provide a basis for saying the whole decision should be unlawful?
There is an issue as to whether he was able to give the evidence that he wanted to give and that he would have been able to give, and how he would have been able to present himself in person. There's a very clear issue about that.
Yeah, but that's not this appeal.
Understood, but we're currently on the section about question about jurisdiction, and there's an admirably succinct summary of the principle in the headnote at page 724 of the report, page 121 of the bundle, at F, where the headnote writer summarises it as follows: although the courts did not assist in the direct or indirect enforcement in England of the revenue law of a foreign state, such a rule did not extend to the seeking of assistance in obtaining evidence to be used for the enforcement of the revenue laws of the foreign state in that state itself. So, in short, there was no jurisdictional limit upon the ability of the English court to assist the courts of the foreign state, even though the underlying substantive rule was one that we in this country would not give effect to.
My Lord, yes, but I don't think that my fundamental point is in effect weakened as a result. I recognize that, but the point that I'm trying to make is that in the discussion that I just had with Lord Justice Lewis, which I think is recognised, and what and the court is saying to me, well, it may not necessarily mean that there isn't jurisdiction. There may be jurisdiction, but whether the jurisdiction is exercised properly in a particular case then becomes an issue. And the way in which I'm putting it is that the exercise of the jurisdiction may be such that you don't have the jurisdiction if you haven't done something which is a prerequisite to the exercise of jurisdiction in the first place. You then begin to go around in circles. Is this an excessive jurisdiction, a want of jurisdiction, or excessive jurisdiction? And I say it doesn't really matter. The real point is, have you done
that? You need a rule of law that says evidence cannot be regarded, and therefore an appeal will be unlawful or unfair, unless the consent of the foreign state is obtained by at least positive consent. You need a rule of that nature. And even if you've got a rule of that nature, you've still got the problems as what happens if you breach the rule of that nature. But you haven't shown us anything in domestic law, Pakistani law, or international law to say that at the moment.
My Lord, the CPR that I referred you to says that you should get the consent of the foreign state, and the interdigital case also makes this clear. This is at 31617.
Yeah, we see now we're getting onto something that I'm really familiar with, because this is my specialist area. So, this is all about German law, because what happened here was that the court received expert evidence as to German law, and the conclusion of the court was, in the light of the expert evidence as to German law, it was at least doubtful whether it was lawful under German law for the witness to give evidence by video link from Germany. But that's all about German law. There's not a word in here about English law, is there?
My Lord, there are some words in here about what international law may have to say on this. For instance, albeit it is in the context of the evidence of German experts, paragraph 9.
Yes, but this is the expert evidence of German law.
I understand your Lordship's point, and formally that is correct, of course.
And what's being quoted here is a decision of the Bundesgerichtshof in 1999.
Indeed.
Stating what German law was.
Indeed. What they are, and in 10 also, and at the bottom of page 620, since the performance of sovereign acts abroad affects the territorial sovereignty of the foreign state, etc.
Yes,
etc.
so this is all this is the commentary on the German Code of Civil Procedure.
But the point that I'm drawing from this, and those are the passages which you'll see on those pages in particular. The point that I'm drawing from this is that this is reflective of a...
But I'm sorry, Mr. Gill, let's cut to the chase on this. Paragraph 45 is the court's finding, where, having considered the evidence of the two experts, the judge says, I think there is a real risk that if this court were to give permission for oral evidence to be obtained by video from Germany without the permission of the German court, it would lead to a breach of German law.
Yes.
So that is a finding as to German law based on expert evidence as to German law. What's that got to do with English law as to jurisdiction?
My Lord, you're absolutely right on that. I'm not actually... That's not what I'm disputing. All I'm trying to draw from this is the fact that those commentaries in German law are reflecting the value which I say exists at an international law level.
But even if it's international law, and even if it was a breach, and even if Pakistan wouldn't have allowed it if they'd been specifically asked, although that's not quite what they say, but even assuming all of that, there is no domestic law prohibition on the evidence having been obtained in a way that might involve a breach of international and or Pakistani law from being used for the purposes of dealing with an English appeal that Parliament says has to be brought from outside the country. You've got to make it such that it cannot even look at it. You can't say they got it in error, it shouldn't have happened, this is shocking and we'll have to apologise to Pakistan. You've got to go beyond that and say, and you must therefore not allow the evidence in, you can't have a fair appeal, you must go back to square one. That's the problem, actually, and you haven't shown us anything to suggest that that is the necessary consequence.
Well, my Lord, my submission on that remains, as I put it, that the courts of this country cannot countenance and should not allow themselves to countenance a situation where they are drawn into taking evidence from...
But it's happened. They're not being asked to do it tomorrow. It happened, rightly or wrongly, at a time when the government thought that it was enough to get silence or non-objection, and it happened, and the evidence was given, and despite your claim that it was unfair, that's not a ground of appeal. So what do you do when it's happened, and the appeal has happened, and the evidence has come in?
My Lord, as I said, whether it's happened or not, on the basis that it's already happened, it is still the case that the court should not allow itself to be drawn into a situation where...
But it has done it. This is not punishing the First Tier Tribunal. Assuming you're right, assuming it shouldn't have happened, it has happened. And an appeal has physically taken place. And a decision has been reached.
Can the courts really allow situations to be perpetuated in that way, where, putting it neutrally, corners for present purposes, corners are cut, relevant prerequisite steps are simply not taken, when they impinge on such important questions as the sovereignty of other states? Can the courts really allow themselves to...
Well, yes might be the answer. Rhetorical questions are always dangerous. This should never have happened, looking back. People are not very impressed with the way the government conducted itself. There may or may not have been an excuse. It's not a Yilmaz case, which was clearly unacceptable. But the short answer is we are where we are in 2021. This happened in 2022. This happened in 2021, and the evidence was given. Pakistan hasn't, as far as I see from the evidence, said this is shocking, this should never have happened, or have they said that?
We are mixing up a lot of points here. The first part I want you, because your Lordship is, I'm not complaining about this, but your Lordship is, on your last point, Pakistan has not been given the opportunity. All they've been told is, in the latest information we have in their fresh evidence bundle, all they've been told is, would you object to the taking of evidence?
And they say we would prefer to do it by a bilateral agreement or an international convention.
Yeah.
It should be done by agreement rather than presumption.
Nothing
but they don't seem to object to it.
This is for the future. Nothing has been said. Your Lordship.
Okay, very well. Don't worry about
important.
that.
Your Lordship
it's important, and I'll take the point. They haven't been asked to comment on this case, and therefore we don't know what Pakistan would have done.
They may
haven't produced any evidence
very angry about
the law, and we don't know what the government response is.
They may be very angry about it.
We don't know. They may not. They may be. We don't know. So I accept that. We don't know.
So back on the question of jurisdiction. You've shown us into digital. Where do you want to go next?
My Lord, on the question of jurisdiction, I put it in the way that I put it in the skeleton argument, and I put it in orderly that the courts cannot allow themselves to countenance a situation where this sort of conduct is permitted, and that's the extent of my submission on jurisdiction. As to the question of whether the court should be, in terms of its discretion or manner of exercise or what it should have done, assuming it had formal jurisdiction to receive such evidence in principle. That is really the greater thrust of our submissions. And we have said that the way in which this policy was formulated, moving to the second of the third way, three ways in which I put my points in the ground 1A, the way in which this policy was formulated, it was designed, it was and had the effect of misleading the tribunals and the appellants. And neither of them were told about why the policy was being adopted in this way. That conduct is such that had it been known to the tribunal would have said, well, formally we might have jurisdiction, but now that we know about the full context, we're not going to allow our discretion to receive this evidence.
So on that submission, I think it would be helpful if you could first of all give us your submission as to what you say the facts are so far as the policy is concerning, and then what you say the legal consequences are.
Yeah. The facts are what is in the fresh evidence, basically.
Yeah. Where do you find that?
It should be in the same, I hope all, well, I don't know if it is in the same file. There was a replacement.
There was a replacement. It is in the bundle, but we were sent a separate replacement, either to keep separate or to replace it. So there will have been at some stage a document like that.
Yes, a replacement bundle.
Yes, we have that, yes.
My Lord, in relation to that, the relevant passages are set out in the skeleton argument, but I will take you through them. I may not pick up all the passages, but because the cross-references are given in the skeleton argument. But can I go to that replacement bundle at page 41, just to keep things in order, although this goes to the point about the president. You see at page 41, there is an email, October 2017, and you see under the heading of legal process, just that first paragraph, if you could just have a read of that. And then at the top of page 42.
So just to get this straight, at 41, the approach they thought would be adequate would be to get a letter from a legal expert in the country concerned, and
they wanted a letter. It was the Crowder letter, if I can call it that. The
they wanted a letter from the head of mission, and they wanted legal advice from somebody in the country concerned. It's two things.
That's right.
Right.
Yeah. And you will have seen those two letters in this case in the bundle, but I'll take you to.
So that was their policy then, that would be enough.
Yeah, that's what they thought. They wanted, somewhat amazingly, the president of the tribunal to tell them whether that would be enough for the tribunal.
Yeah.
And we say on that point, if that was going to be done, it should have been done, bearing in mind test cases were being set up in the context of a hearing at which there were several CMR hearings. They didn't do that. They went behind the backs of the appellants. Moreover, at the bottom of that page, it says, as previously, the specifics of notifying authorities that are a match for the FCO locally and a variety of approaches will apply depending on the nature of the relation. There has been discussion in the past on handling. We're not attempting to change preferred approaches. In particular, In particular, we're not expecting there to be a formal request. So not even a request, never mind a formal note verbal. Any email will do, it seems, to the government of the country because of the time delays and other potentially unwelcome consequences. In other words, there is a deliberate intent not to be open and upfront with the foreign state. They know that there are certain test cases coming up, which were going to be before the president. It is not known to us whether what was being done behind the scenes by the Secretary of State in formulating this policy was ever actually communicated, or the reasons for it was actually directly communicated to the president. It doesn't look like it. It certainly wasn't communicated to Congress. Page 43 is important. This is the sort of draft that they produced in our case, or the sort of letter. And look at the comment in the margin. It says FCO to describe this in the way that they, it's very small, the way that best suits the diplomatic approach would make it clear that someone at some level of government machine has been notified. In other words, send it to anybody. That's how I read it anyway. It may get buried. We may never get a response. And let's just hope for the best and leave it like that we don't get a response. That's what this is doing. At page 45, this policy is saying, thanks very much for the follow-up. Interestingly, in all 4 priority countries we've been focused so far, local FCO contacts have been very relaxed on this issue. We're letting the host government know via the missions, but not asking permission. Deliberately not actually making it, asking them. We are proposing to put in place a system of video link appeals where evidence will be given by your nationals on your territory who we have removed. We can't give you their personal details because that would involve breaches of data requirements and so on, and a breach of Article 8 on conviction and so on. But will you give us permission to actually hold such hearings? Will you do it on a general level, or will you? Do you want to know specifics of individual? They don't even need to say the latter bit. So
well, their position is it might be right, it might be wrong, it might be based on a reading of Nair, but they think they don't have to ask permission, and they think it's enough to notify and get silent, and that may be adequate, it may not be adequate. Well, that's the position, isn't it?
Well, my lord, I referred in the skeleton argument to acting in good faith in international law. Well, this is a general principle.
Yeah, but how does this? I mean, that really is to do with international relations, isn't it? I mean, I understand. We know what they did in Yilmaz, and the court was rightly critical. We've seen these letters, and I understand why you make a submission. This isn't a good way to go about it, not expressing any view on that. But the bottom line is what they've decided to do is they're not going to seek a positive agreement for the reasons they've given, but they're going to notify, and if there's an objection, they'll stop, and if there's no objection, they'll not stop. That's what they were going to do.
My lord, I'm taking you through the evidence, but bearing in mind your lordship raises that point, put it in this look at it in this way. When one country is approaching another country and telling them that it is going to do something, and it knows that it needs to actually engage the other country, you don't just say, we're notifying you, do you have any objection? If you're going to act honestly, transparently, call it whatever, good faith, whatever, doesn't matter. Common sense approach would apply in national law or international law. If you're going to be honest about things, what you would say is, this is why we want to do it. You are not a Hague Evidence Convention
We can
country.
see the force of that submission, but what we're troubled by is what's the legal relevance of it. Because there are 2 possible things, and I'm not quite clear at the moment exactly what your argument is. let's assume that you're correct in saying that if there's a requirement to get consent, this is insufficient.
Yes.
Now, that then leads on to two questions. First of all, is it your submission that there is a requirement as a matter of domestic law to get positive consent, positive and informed consent from the foreign government? If so, where does that come from? Secondly, if that's not what you're submitting, I do understand it to be your submission that in some way the FTT was misled, and I'm still struggling to understand in what respect you say the FTT was misled.
Those are both my submissions.
Right, so where does the requirement for positive informed consent as a matter of domestic law come from?
I've taken you to the relevant parts of the CPR. I've taken you to the relevant guidance, which was in existence at the time at the tribunal level. What I would respectfully submit is that when that guidance, and Mr. Justice Blake's 2013 guidance that we looked at in the FTT, says, if there is any doubt, you've got to make the relevant inquiries. There was this conduct was intended to create a doubt, and knowing inquiries were then followed up. They left it in a dubious position. We're not going to ask them for permission. Why? We just notify somebody. We're not even necessarily going to do it by a note verbal, which would attract a response, presumably. Whereas an email to somebody in London, the Pakistan High Commission in London, may well, they know how the system works. It's going to get lost in the system and nobody's going to respond.
Well, there's no evidence that the Pakistan High Commission routinely loses emails or doesn't treat them seriously when they come from the Deputy Head of Mission in Islamabad. We simply don't know, and I don't think we can presume that a foreign country is going to operate incompetently.
So, well, as your Lordship pleases about that, the fact remains that the evidence, the notification was sent deliberately in that way. We don't even have the notification. There is no evidence that it was ever followed up. There's no evidence of any request.
All right, but to come back to my two questions, your answer to my first question is you do submit that as a matter of domestic law, there is a requirement of positive informed consent on the part of the foreign government, and you say that comes from the CPR, NER, and the President's guidance.
Yes, and I haven't referred you to the Chancellor's note of May 2021.
All right, let's have a look at that.
But that is at page 56. And this is how he understands the previous guidance. So he gives a practice note, Authorities Bundle, page 56. Paragraph 2. Uses the word permission. Authorities Bundle.
Let's look at what he says. In a number of cases, the issue has come up in relation to witnesses giving evidence by video link or other remains from foreign jurisdiction that permission may be required from the local court or other authority in the foreign jurisdiction. So he's not saying it is required, still less is he saying it is required as a matter of domestic law. What he's referring to is cases like interdigital, that being a case within his jurisdiction, where as a matter of the local law, it's required.
My Lord, I accept all of that. What he's drawing attention to is the fact that you've got to make the relevant inquiry in the right way. And what you've...
He's not even saying that, he's actually saying may be required, and it's for the party calling the witness. On a strict reading, it's Mr. the appellant who's making it, but here the situation is different. He's only doing it that way because he's got the 94B certificate. But the wording of the guidance note, paragraph 1, doesn't actually help because it doesn't actually apply to this kind of situation.
Well, what it is drawing attention to is that where it is necessary, it may be necessary to get the permission, depending on what they say, and you've got to basically make sure that you've got that permission if that's the case. What it is doing, what it is indicating is you've got to engage openly and transparently in the way that you would with a Hague Evidence Convention country, because as you will have seen from the Hague Evidence Convention, it's in the authorities bundle, and I don't necessarily want to take up time going through all the steps that it sets out, but it says what you should actually be doing when you make the request to the other state. Now, if your bilateral request, for instance, it says what you should, about the why you need the evidence, what sort of evidence it is, etc. Now, if it's not a Hague Evidence Convention country, we say that you've got to follow a procedure which is substantially akin to that. That's the phrase I used before the upper tribunal on the 28th of July 2021, when I was saying that this just didn't happen. And that phrase is now what they've picked up on, and they've now put in their more recent guidance, akin to. So they now come round to, but they only came round to that once Mr. Peck's statement of the 8th of July 2021 in Yilmaz disclosed the fact as to how they were interpreting NARE, which the tribunals were never told and we were never told.
Well, you need to look at what you say the tribunals do. I understand you say the reasons behind the policy were not told, but there's no doubt that the tribunal in this case had a witness statement with a statement of truth saying what had been provided, and they were attached. And you did say at one stage that the FT was misled or wasn't told anything, but it was told something. But you will say that what they were told was not enough, I think.
Yeah. Okay. Before I just get on to that, can I just you were asking me to go through the evidence, so I'll try and speed up a little bit. At page 49 of this fresh evidence bundle, someone raises the problem within their ranks. He says, we start about talking about consent, but in fact FCO seems to be ensuring there are no objections rather than seeking consent, question mark. So they would alive to the distinction.
Problem is, we don't know, and it's not your fault, but we just don't know who this comes from and who it goes to, although we know Mr. Bennett's copied in. We've had this problem with the Home Office and other departments before. It's very difficult to make any sense of things at all unless the government department fesses up and say which department and which person. And that isn't a breach of any laws, and it would be quite useful. But they're not helping us for perfectly understandable reasons.
Let me just move through this fast. At page 51, in the middle of the page, it talks about the strange language. Mr. Clements may be persuaded the FCO letter is enough. Well, how was he going to be persuaded? What effect was that going to have on other divisions of the tribunal? We have no idea. We don't want to go down formal letters to governments, as this will always introduce time delay. So, informal approaches. Then there is at page 56, at the bottom, the President initially indicated he would like written consent. This is not what we're planning to do. So that was the indication, but they decided they weren't going to do it. And then they think, however, the President may hopefully be satisfied by a different type of letter. And then at top of page 59, it's difficult to tell, but the President is happy with some letter or other that you put before him, presumably the standard letter that we're talking about. And then other passages, Lord, are referred to in the skeleton argument. And at page 68, once this issue starts being opened up as a result of the disclosure in Yilmaz, in a note to the Minister and to the Home Secretary, you see that at page 66. At page 68, paragraph 9, they set out their approach. Third line, if no negative response to our notification is received. from the foreign government after a reason we interpret the absence or of a response such as not a condition that the country has raised no objection. So they chose to read nare in a certain way. And that's not what is really the thrust of nare. We have adopted that position to avoid the inevitable delays that would arise if we only proceed on the basis of positive response. On the basis we would inform our colleagues working overseas that in the wider perspective of diplomatic relations, notifications do not always receive a response. Your Lordship said we cannot presume.
No, you're accusing the High Commissioner in London of being incompetent. I don't think it's fair to do that.
That is absolutely right. But my point is that if you're sending simple notifications informally to persons who are not necessarily the right section, you're unlikely to get a response, or you may not get a response, and they know this, and that's why they adopted this policy. That's the bad one. There is a deliberate bad faith here. They did not tell any of this to the president. They put a letter before the president in some unilateral discussions where they didn't even tell him that. Now, for all I know, there may be judicial meetings. I have no idea of knowing this. I'm making no accusations in relation to this regard at all. And the president sat on a number of these test cases, so we don't know what happened. As to the evidence is at page 320, where of the hearing bundle, where he says, where one witness says, I can confirm the FCO advised the Pakistan High Commission that the use of a video link was being given, etc. And you see, and then he attaches the letters. That's all. What we have.
He also attaches the letter from the law firm. It's not all. So you have to say
both
it's
letters.
accurate. Yes.
Both letters.
Well, this is enough as another question, but we need to know the facts.
I'll deal with that fast in a moment. At page 321, we have a letter.
Sorry, I'm sorry to slow you down. I appreciate you're trying to make progress. But 2 points here. First of all, the evidence that was put before the FTT was that there were no legal barriers in Pakistani law preventing the giving of evidence over a video link from Pakistan to a UK court. Now, let's be clear. You're not challenging that.
I am.
So where is your evidence in Pakistan law that that's wrong?
I don't need it. Can I explain it in this way, Lord? If you allow me, I will deal with the point. I know what's concerning you. First of all, at page 321, it says there is a letter from someone in the High Commission in Islamabad, and it's to an addressee which is not known, presumably a relevant tribunal or other. So this was what they were planning to do. And this is what was put in the evidence in our case, in due course. And all it says is what is there. At the bottom has been notified of our plans to make facilities available. No,
that's a different point.
I know.
So my question was about Pakistan law. And
I'm coming to that.
We have two pieces of evidence that are put forward. There is the letter from Mr. Crowder saying that checks has been made, legal advice he's received, there's no legal barrier to this activity under Pakistan law. And then there's the letter from a partner in Khan and Paracha confirming that statement.
Yes.
So where is your evidence from an expert as to Pakistan law saying that under Pakistan law you can't do this?
It's not my obligation to produce that evidence. The obligation is on.
So we have unchallenged evidence that it's not illegal under Pakistani law and no evidence to the contrary.
This is not evidence that the tribunal should have taken into account. And the reason why they should not have taken this into account is this. This evidence simply does not meet the standards for
expertise. That's a different point. This is not a point about whether they've got enough consent. This is a separate point.
It is.
The law of Pakistan, what does the law of Pakistan prohibit or permit? And that's what we're currently focusing on. It's the second letter, the Khan and Paracha letter, as to whether Pakistan has a provision in Pakistani law that says this can't happen.
I agree, my lord. I was finishing off on that point. Lord Justice Arnold quite rightly asked me about evidence in relation to Pakistani law, and my position in relation to that is this, if I can now deal with that.
Yes, certainly.
My position is that where the Secretary of State is going to say that a lawful, effective appeal from abroad can take place, and it can take place because we've made relevant checks, that evidence by video link can be taken from Pakistan, it is for the Secretary of State to demonstrate that fact. The Secretary of, this is the consequence of Chiari and Brindloss, which you will have read. The burden is entirely on the Secretary of State to demonstrate all of this.
But she's demonstrated it so far as the law of Pakistan is concerned. Whether or not, as a matter of diplomatic relations, Pakistan wants to do it is for the moment a separate problem.
Well, my lord,
but if she's gone to ask lawyers in Pakistan, is there a problem with this? And the lawyers say, no, there's not. What more is the Secretary of State required to do on the question of the law of Pakistan?
Oh, my lord, who is the partner who writes a one-line, is it a lawyer? Are they qualified?
Well, it is a partner in a law firm in
maybe a non-legal partner.
It's unlikely the Secretary of State would have gone down to the market in Rawalpindi.
Well, so there's two. Let me ask you two questions. First of all, am I right in understanding that there was no contrary evidence before the FTT? That is to say, there was no evidence before the FTT that it was illegal under Pakistani law.
You're right, but that's not the point.
So the only evidence before the FTT was evidence that it was legal.
The only evidence was this letter, and that is all. And I say this letter isn't worth the paper it's written on.
Why?
Because, for the reasons we've set out in the skeleton argument, that this is, if you're going to have evidence of foreign law, as was put to me earlier, it's done in a certain way.
No, that's consent. This is different. The government might not even have wanted to contact Pakistan. If they got a letter back saying, no, Pakistan law prohibits this, read Code 654, they might not even have bothered. The first question is whether it's the law of Pakistan, and the obvious place to go to, and these people would almost certainly have been the Honorary Legal Counsel, because most areas where we have an embassy, they go to a local lawyer to get advice on local law. And that's what they say they do, and that's what they've done here. This is a firm of lawyers. Amu Piracha is one of those, and he said there's not a prohibition. He may be right, he may not be, may be wrong. He may be a good lawyer, may be a bad lawyer. But that is a lawyer in Pakistan saying there isn't a prohibition.
My lord, you have my submission that if somebody is going to say, we can give you a lawful and effective appeal from abroad, and we can do it because we've checked that there is no legal objection in that country and sought the consent of the foreign state, then in relation to the point about legal objection in relation to that country, they need to produce evidence. A one-line letter like this.
Sorry to interrupt. So, would it have been right? I mean, what are you saying they should have done? They should have put in a witness statement, a statement of truth, saying I, Aman Piracha, am, I'm a solicitor qualified in Pakistan. I've got a law degree from so and so and so and so. I've consulted all the textbooks, and this is my opinion. I mean, what standard of evidence are you saying would suffice, or would nothing suffice? I'm just trying to test your submission.
Well, my lord, my lady, if you look at the sort of evidence that there was, for instance, in the interdigital case, I would respectfully submit, it's fairly straightforward that you've got to have clear evidence from a qualified lawyer who meets all the CPR rules on expert evidence, because what we're dealing with is foreign law.
The CPR rules don't apply in the upper tribunal or the lower tribunal. That's what often happens there, and we have lots of problems in this court, as you well know, because things are allowed in at the FTT level that wouldn't be allowed in here. You have country guidance experts, you have professors of this and professors of that, and so on. So it isn't right to say or relevant to say that it's not a CPR expert.
My
There's
lord, I
been
can...
no request for expert evidence, and they didn't need to have it.
My lord, I didn't think that this was ever going to be contentious, and the other side have not actually said anything about this in schedule 9, and if need be, I can check the tribunal authorities, because there are authorities which say that if we're going to have expert evidence, it's got to meet certain standards.
But then you need to show us that. I mean, and if that is the case, I'm surprised, given that this was given at the First Tier Tribunal, and there is a judgment dealing in part with this, and in fact you represented the client. I'm surprised that that objection doesn't appear to leap off the page from the tribunal decision on the 10th of March, I think it was, saying Mr. Gill submitted that this evidence was not expert evidence and failed to meet Tribunal Rule 1, 2, 3 and 4 and should not be given any weight. I mean, none of that seems to have happened, or did it happen?
I absolutely made it clear that this letter is wholly inadequate, and that this other letter on 321 is also wholly inadequate for the reason.
321 is a different question. We're on to a very discrete point at the moment, which is evidence of Pakistani law.
Can you help me on this? If you submitted to the First Tier Tribunal that, to adopt the words you used a moment ago, the letter at page 322 from Khan and Paratra is not worth the paper it's written on, and I understand why you made that submission. If you made that submission and it was not addressed in the FTT decision, you would have done two things. First of all, you would have said to the FTT when you got the decision, you haven't dealt with my point, please supplement your reasons to explain why you've rejected that submission. The second thing you would have done, even if you didn't do number one, is it would have been a ground of appeal on your appeal to the UT. Now, did you do either of those things?
It was raised in the upper tribunal as well.
Where are your grounds of appeal to the upper tribunal? Where do we see that?
I will have to get you the reference rather than...
I think it's page 205, isn't it? Or is this in the ground in the First Tier Tribunal? Another set, perhaps.
No. This is the...
That's the one in the FTT.
Yeah, my lord. It may take a bit of looking through in order to try to find the relevant. But I will give you the relevant paragraph numbers. But I didn't for a moment.
I wonder if it's page 142. In the upper tribunal, amended supplementary grounds of appeal.
Oh, it's in a...
Well, those are your amended grounds in the upper tribunal, are they not?
No. 171 is where the... I'll have to find the passage in here as to...
Oh, so there's supplementary and there's amplified.
And it was raised. It was clearly raised at all points. And I will find it, but rather than taking up the court's time at this moment as to where it was, the position has always been put on the basis that it is up to the Secretary of State to show that they've carried out a lawful process, and this evidence on both of these points, consent point and the law point, simply wasn't enough. They had simply not discharged the burden. It was put in that way. On that basis, the tribunal, the upper tribunal, basically said, well, there was evidence before the FTT, and it was in this form of these two letters. And because they were addressing the point that was being, or seeking to address the point being raised to show them that this hadn't been dealt with.
That's the paragraph 53 of the upper tribunal decision at
Yeah.
page 90. It starts at 53.
Yeah.
Well, it started a little bit earlier, 50 really. It starts by saying doubt about how to receive video evidence. Then you go through now, and then you get to 54, which says there's been the two documents. And then 55 deals with the letter from Pakistan. And 56, it does record that you say they're both inadequate.
Yeah. I don't think there was any issue that this was clearly on the table. As it
So there's
were.
nothing so much, the paragraph 56 appears to be recording more the detail of what you say about it.
Yeah.
And then 58 says, we're satisfied that they were enough to deal with, one, the diplomatic, and two, the legal concerns.
Yeah. And we say that in a context where the Supreme Court in Carr and Brindloss had made clear that it is up to the Secretary of State to make all the relevant inquiries, even before a Section 94B certificate is issued, as to how an appeal from abroad would take place, not just logistics and mechanics, but these sort of legal impediments, so all impediments, because Nare was referred to in that. We say this inquiry was never made, and it was never made even after the Supreme Court judgment was handed down.
The problem that I've got is we've gone round this. This is not a judicial review of the Section 94B certificate. Yeah. It's not a judicial review of the fact that the appeal had to be brought from outside the United Kingdom. This is an appeal against a finding that refusing to set aside the refusal of the human rights claim would not itself involve a breach of Article 8. You're back to the situation, whether or not this should have happened, and we've got the certificate, we can't go behind that, whether or not this should have happened, whether there should be further checks. It was given, and the evidence is that it's not actually contrary to Pakistani law, and we're still back to, you have the same submission, it shouldn't be allowed. It sounds rather like a public policy punishment thing. If they haven't got the checks done, then the person concerned must have a second appeal starting in the FTT and presumably must be brought back, or agreement must be reached with Pakistan to have a video link.
Yeah.
I mean, that's the bottom line, isn't it?
Indeed it is, indeed. The point here is that the FTT, we're told, in cases like AJ and so on, is able to control its procedure so that if there has not been that relevant inquiry to ensure that a lawful, fair, effective appeal can take place from abroad, then the FTT will be able to give, so we're told, some form of an indication that the appellant should be brought back. And if the appellant isn't brought back, then what should happen? What could happen is that the Secretary of State's refusal to follow that indication would then be the subject matter of judicial review. So we're locked out of the judicial review for the reasons that your Lordship has seen on the papers, because it is the case that it is said against us that the FTT can provide the remedy, but the FTT doesn't provide the remedy because it doesn't engage with this question properly. I think your Lordship has my point in
I understand the point, yes.
Yeah, and which is why the answer that this is not a judicial review doesn't actually meet my point.
Well, I can understand a degree of frustration that you're caught between a rock and a hard place because in each jurisdiction you're told raise the point in the other jurisdiction. That's sufficient I can understand. However, can we come back to where we were? Because you were making a submission to the effect that the evidence as to Pakistani law was inadequate. And I understood your submission to be that the reason why it was inadequate was because it didn't comply with, in effect, CPR Part 35, which lays down the requirements for the admission of expert evidence generally, including expert evidence as to foreign law. And what we were exploring was the extent to which that objection had been taken below. As I understand, you say it was taken below, but it is noticeable that in reciting your argument of paragraph 56, the UT doesn't refer to part 35, it refers to part 34, which is all about the question of the process of obtaining consent. And in any event, their conclusion is that the evidence was adequate. Now, I appreciate you want time to check your grounds of appeal below, and I understand that. Let's assume for the moment that the objection as to the admissibility of the evidence was taken, at least in the UT, if not before the FTT. Why do you say that the lower tribunals erred in law in admitting the evidence?
If the evidence does not meet the standards set by the UT itself for receiving expert evidence, it would, with respect inevitably, which are similar to those.
That argument seems to be a bit circular. Where is the source of the legal obligation which you say has not been compliant?
My lord, I'll get you the case law in the upper tribunal, which says that if you're going to produce expert evidence, you've got to produce it in a certain way, and it is fairly similar to the standards standards adopted in the CPR. It's so basic that it was staggering that the tribunal faced with a statement, this is plainly inadequate, isn't it? Just look at it, then say, well, it's something.
I must confess I hadn't understood from your ground 1A, this court, that the problem was thought to be the inadequacy of the evidence relating to the law in Pakistan. I had understood from ground 1A that the real criticism was your complaint that a vigilant can't lawfully be held because there's what you call a secret policy of presuming commission from a lack of response to a notification which was deliberately avoided seeking the foreign state's permission. And that was what I understood was the problem, the lack of consent from the authorities in Pakistan rather than this evidence is rubbish. I don't get any sense that that's the problem.
Well,
and it is relevant because there are two different things. There is this a breach of Pakistani law which will have civil or criminal consequences, and is this a breach of international comity between nations?
Well, my lord, I'll give you some references if I look at them over the lunch break on that point and leave it at those references. But it's such a ground one is asserting there was no lawful basis for
yes,
this.
And the reason why there's no lawful basis is because the lack of consent
Well,
from
it's
the
not just
Pakistan
that.
government.
The burden is on the other side to demonstrate that there was. But anyway, I may be. Yeah, we'll give you the chapter and verse in due course.
We will have to consider whether this is encompassed within your ground of appeal,
Well, on the
1A,
basis.
but as I understand it, the submission you are now making, let me be clear, the submission you are now making is that the FTT erred in law because it admitted expert evidence as to Pakistani law which was inadmissible. That's your submission.
Yes. So there is another issue here as to why the consent of the foreign state is particularly important. Different states have lots of different traditions. Some have common law systems, some have civil law systems, some have mixtures, some have systems of law which are supplemented by other types of law, such as religious systems of law, which carry just as much weight. And then they have all sorts of practices and guidance documents and so on, which are not necessarily always apparent on the surface. And one has to dig really, really deep, or they may only be buried in some government department somewhere. This makes it all the more important that you've actually got to go to the relevant foreign state and ask them, is it contrary to your laws? We believe it is. Do we have your consent? Because this is what we're proposing to do. So you've got to really be quite open and upfront about it.
Yes, and that leads on to your submission. You say the FTT was misled.
Yeah.
And I'm sure it's my fault, but I'm still unclear as to in what respects you say the FTT was misled.
Yeah. In relation to that point, the FTT and the appellants were misled because there was a failure to disclose the policy of not seeking consent and the reasons for that policy. Had the...
Well, I'm sorry, I'm still struggling to understand that submission. Can we please return to where we were, which is page 320? This was the evidence before the FTT. And the key sentence is the last sentence of paragraph 8. I can confirm that, to my knowledge, no objection has been raised by the Pakistani government to the proposal to use video conferencing equipment in appeals to a UK court. So he does not say that consent has been given. He does not say that consent has not even been asked for. He simply says no objection has been raised. So how is the FTT misled?
Where the Secretary of State has devised policies of one sort or another, which are relevant to a appeal before the tribunal, and the disclosure of which may assist the appellant, the Secretary of State must disclose them. The Secretary of State had such policies in this case, which they devised.
But there's no mystery about this. If you read paragraph 8 and you read the last paragraph of the attached letter, what's been said is quite clear. Pakistan High Commission in London has been notified of our plans. No objection has been raised.
It's
So
what is
that
missing.
might raise a question in your mind. Well, have they been asked for permission? But there's no suggestion they've been asked for permission.
And the policy is to notify the relevant High Commission and to see if they object. Whether it's a good enough policy is another question. Whether it's adequate is another question. But they have described what they've actually decided to do. They may not have set up the reasons why they're worried about delays, they're worried about bargaining chips. The other side might say, oh, we'll use that as a way to get them to shift to something else. They haven't given you the thinking, but they've told you what they do. The policy is to tell the Commission, and unless they object, to plough on. And that's what they've asked you to do, you, the tribunal, to do.
My Lord,
It's obvious from the letter that they haven't asked for permission and they haven't been given permission.
So
So
you were
you
able to
don't-
make that submission to the FTT. You could
don't
say, on the
need-
face of this evidence, look, they haven't even asked for consent, let alone got it.
So you don't need to know about their policy. It's obvious from the material that you've got that permission hasn't been sought or given. I just don't understand
my Lord, the point was
what the
made.
secret is.
Point was made that they are simply looking at no objections, and they're not actually saying that there's been any sort of request for permission. And
There hasn't been, and they know
There
that
hasn't
because
been,
they've
and
told
they're not
them.
suggesting there has been.
if they were then to set out their policy, and if they were then also to set out the discussions that were happening with the president.
Well, the president is a separate issue, but the policy, what is the policy? What must, in their view, do, or what are they going to do? And the answer is they're going to tell the Commission, and they're going to wait to see if there's an objection. And that's precisely what they told the FTT.
Oh, my Lord, the emails that I took you to earlier.
Explain the reasons for it, delay and bargaining chip.
But why do you need to know any of that in order to submit to the FTT? This is inadequate because they haven't told us that they've asked for permission, still less have they told us that they've got permission.
Because
Perhaps
what
submission
this...
is open to you on this material.
Oh, the point was made to the FTT, but what it does is that it lulls the FTT into thinking, oh, they've asked...
But it doesn't lull the FTT into thinking anything. The FTT aren't stupid. They can read English. They can see precisely what the position is from the material. I'm just not following this submission at all, I'm afraid.
Well, lady, if the Secretary of State has decided to take a certain policy route for a certain reason, and in this case, in order to avoid unwelcome consequences is the phrase that is used.
Yeah. Well,
Now-
so what? Nobody's being misled. Nobody suggested that the Secretary of State or the Foreign Office or whoever it is have asked for permission.
The
They
unwelcome
don't say they have.
Well, I beg to differ on the lady that this is a matter of some importance, because what you're doing is you've got to be upfront with the tribunal to lay your cards face on the table so the tribunal can see.
Hold on a moment. This is not about the validity of the certificate. This is about whether he can give evidence, and he gave evidence.
Absolutely.
That happened. They are saying, we think it's okay. We know you've raised problems in there. We've told the Commission. They haven't objected. We've gone to a law in Pakistan. He says there's no problem. So the tribunal, rightly or wrongly, decided, right, there's no problem, and we're going to hear the evidence. That's where we've got to at the time of the hearing in March 2021. Now, it may be, looking back, that they could have been clearer. It's nowhere near as bad as Yilmaz, when they didn't even tell the court that they'd had a positive statement from Turkey, that Turkey didn't consent. It's not as bad as that. You may say, well, this is Foreign Office speak in spades. Dear me, it's what they don't say. It's what they leave out. It's all these discussions with the president, whatever they are, to do with anything, that creates a bad picture. And that's all very, very interesting if you were A, a tribunal of inquiry, or B, a court of judicial review. But we are hearing an appeal as to whether or not the tribunal was correct to say that the consequences for the wife and children would not be severe and bleak, and therefore there would not be a contravention of Article 8. That's what we're talking about, and I get the real sense that you're trying to punish the tribunal, not because they've got inadequate evidence, although you think it is inadequate, but that's not your case, but because more wasn't told to them by one of the parties, or because what you say is the correct position wasn't realised. And I do wonder whether that is the purpose of an appeal. Should somebody who's been deported, because Parliament says he should be deported, win an appeal, not on the evidence he produced, but on the fact that one government department was not as forthcoming with the FTT as you say they should have been? That's my difficulty.
My Lord, if the tribunal had those emails, had that context explained to them, what would they have done?
We don't know. They went on and heard the evidence. And that's where we are. And the question is, should you now be punishing them for that? That's the issue.
Lord, is it not a reasonable likelihood, almost I would say, strictly inevitable, that the tribunal would then have thought to themselves, Gill is complaining about the adequacy of these documents. Now we actually have this context as to how these documents are created and why they only say a limited amount but don't say the rest.
All right, but
What does this tell us?
To summarise, as I understand it, your submission is this, that the FTT was misled because there was a positive duty of candour upon the Secretary of State to disclose that she had a policy of not asking for positive consent and the reasons for that policy. You say that's why they were misled.
Yeah.
Even though the material put before them accurately stated what was done and by implication what was not done.
The implications are important, and what is the tribunal did not take those implications into account at all. This is.
But it would have been open to you, Mr. Gill, you've looked all over this, say to the FTT, well, this is all jolly well, but you haven't been told whether or not they've asked for consent, and you haven't been told whether consent is being obtained.
I said to the FTT, this doesn't amount to permission of that state.
Right.
This is wholly inadequate. All they're saying is they've written a letter and they've got no objections. Yeah. That's all they're saying.
Well, indeed. So you made the submission and it was not accepted.
Yeah. And they decided not to. Yeah, exactly.
And the point is, if they'd actually disclosed to the tribunal, they had this policy for the reasons set out in the skeleton argument. I referred to a number of cases on the duty of candour, case of. I don't want
but
to.
that's in judicial review proceedings. This is not judicial review, is it?
It's not just in judicial review. This tribunal is entitled to look to see whether the appellate proceedings are being tainted by the lack of.
That's simply not correct. If there's a breach of the duty of candour in judicial review, and if it applies elsewhere, it will be the same. One of two consequences can happen. You can apply for specific disclosure of the documents that you say are not being disclosed, or alternatively, you can invite the tribunal to say that they should draw adverse inferences from the respondent's failure to comply with the duty of candour. I doubt that you'll be able to find a case which says if the duty of candour has been breached, thereafter the hearing itself is tainted or invalidated. That's not the way the duty of candour works. Nobody wants to underplay the duty of candour. Governments should be truthful. And if they're not, they'll be hauled over the coast white as they were properly in Yilmaz. But it is not the case, nor is it in the public interest, that legal proceedings are thrown out of the window because there has been a failure at some stage. If the failure is material to the actual appeal, they've hidden things about the family or the children, and the tribunal has actively thought something about the family that wasn't true, that would be a different matter. But that's not what you're dealing with.
Well, my lord, if your lordship tells me, and I think you're saying this is more of a JR point.
No, I'm saying the consequences in JR, and assuming it applies in the FTT, would be the need to get documents or the need to invite adverse inferences. Neither of that would involve an invalidation of the entire tribunal hearing. If the tribunal hearing had been in some way tainted on the evidence, the father was compelled to say things, that there was somebody standing behind him with a gun in the embassy or the visa centre saying, say this or I'll shoot you, that would be a different thing. But that's not this case.
My lord, I respectfully submit, you may disagree with me, that it does have an effect upon the legitimacy, upon the legality well, if the tribunal had been told of that context, and if we'd been told of that context, we would have said, look how it is that they're not in fact seeking even the permission.
So you'd have stopped the giving of evidence and the
But
appeal would have
Mr.
gone
Singh, you
ahead.
just contradicted yourself, because you told me earlier that you did submit that this evidence doesn't show us that permission is sought or obtained. So nothing was hid from you. You were able to make that submission.
Let me put it in a different way. You're right. The point would be that the tribunal would have a better basis before it on which to actually accept the point that permission hasn't been sought.
But what more do they need? Nobody's told them that permission has been sought or received. Clear on the face of the documents what the government's saying has happened. Well, anyway, your submission is somehow or another they were misled. I'm not sure we're going to be able to get any further, are we?
The only thing I can say to you is, imagine if you were faced with that evidence sitting in the tribunal, what a tribunal would in fact do. They'd say, we thought that you're saying no objections. This party is saying, well, that letter isn't good enough. It's simply not good enough to say no objections. You've got to do more than that. But now that we see why the policy was adopted in order to avoid negative responses, we, the tribunal, can see something dodgy has gone on here. And if an actual request had been made, it is at least possible that the Pakistani state would have said, no, actually, we think there are objections as to law.
Just pause. Let's work out what would have happened. You'd have told them there are bad things happening here. The reasons are not good. You can't have this evidence from Pakistan. It's not right. Tribunal would have said, you're quite right. That's not how it should be. Let's adjourn. Let's have the appellant brought back to England. Then you give the evidence. And then they reach the decision.
Yeah.
And everything that they had, then they would have now. So what's the problem? The problem is that you are trying to get a second appeal because of failures, you say, about the evidence in relation to the first appeal. But if you look at the purpose of the proceedings was to allow an appeal by the father to say that being separate from his wife and children amounted to a breach of Article 8 and therefore shouldn't be allowed. You would have liked to have given the evidence in person, but the law at the moment, we'd assume, was that, certainly in this case and perhaps more generally, there's nothing unfair about that kind of evidence being given over a video link. So what you're really saying is, although the evidence was given, and although they reached a view on it, the fact that there were, we'll call them procedural shenanigans behind the scenes, is enough to say we'll go back to square one, start again, and we'll have the evidence again, the evidence that they actually received. That's the difficulty that I've got.
Your Lordship said the evidence they've actually received.
Yes, from the appellant.
And I have already made the point, admittedly bundled in with other points, is that one of the problems is that giving the evidence across a video link...
Yes, you don't like that, but that's the law. That's Section 94B, and that's where the world is after the pandemic. It's perfectly normal. It's not unfair. He might have preferred to do it differently, but it doesn't make it unfair. The fact that there may have been procedural shortcomings about the way in which the evidence was given is not the same as saying, therefore, the evidence itself is in some way tainted or diminished. That's the only point I'm persistently making and trying to get you to respond to that.
My Lord,
anyway, you know the point that I'm trying to make.
Well, my Lord, yes, but can I just make 2 points in response? The tainting is partly to do with the fact of these dodgy shenanigans.
Procedural shenanigans, call them what you will.
Yeah.
Yes.
You can't behave with a tribunal.
No, they shouldn't, assuming this is dodgy. But
secondly,
what happens next?
Secondly, tribunal, the court should not countenance that sort of behaviour.
We're not encouraging it. We're asking whether anything has happened to the appeal which is somehow different because of those procedural shenanigans.
In relation to that, there are cases in which you can take video link evidence from abroad and can take it fairly. Lord Wilson pointed to the possibility that could
You're
be
mixing up the fairness of video links, which is not at issue, with the fact that you think the video link was obtained in a way that wasn't procedurally open?
No, with respect, I'm not mixing up the points. The difficulty with, and it's at paragraph 61 of the Supreme Court's judgment in carrying videos, where he recognizes that there are real deficiencies in giving expungement. Now, true, technology has got better, but it's not simply about technology. Let me just take it to paragraph 61. It's in at
Page 322, the authority bundle.
yes, and can I just invite the court to look at it?
As a witness statement would do, there's got to be oral evidence, yeah.
In any event, I can imagine statement will generally, so he's got to give oral evidence. We'll want to hear how he explains himself orally.
Yep.
Then another strand is the likely to be the quality of his relationship with others.
Yes, but that's just about giving oral evidence, not about whether you can do it by video link.
True. And he can't, as I said, Lord Wilson contemplated the possibility. It might be possible to do it by video link, but you've then got to explore the possibilities of how that could happen. Can it happen legally and so on? Secretary of State has made no such inquiries, which is why the Secretary of State stopped all decision making to make sure that they had tried to put in a process.
Yeah, all right.
Now,
but summarising your submission, or your second submission under this heading, you say that the FTT was misled because the Secretary of State failed to disclose her policy of not asking for consent and the reasons for that policy.
Yeah, because if they had that, the tribunal would then have had more of a basis for drilling down and saying, well, it's up to you, Secretary of State, to show that a lawful procedure can take place from abroad. So, have you done so? And we go back to what you were saying to me earlier, what would have happened?
All right, so is that a convenient moment to go on to your third submission, which is the involvement of the President of the FTT?
Yeah, just before I go on to that, the tribunal in this case took a view about the appellant as to, they made an assessment of him and said, well...
yes, and your point is that if they'd seen him in person, they might have assessed him differently.
Absolutely. And we were denied that possibility because of an illegality.
Yeah.
And so one cannot be satisfied that the results would necessarily have been the same. And you have refused permission on other points about the quality of the video link and so on, and the fact that we had to keep running out of the hearing.
No, not that you're alleged to keep having to run out. We've got two decisions of the tribunal and I refused you permission. So
yeah,
your view of it is very interesting, but it doesn't, I'm afraid, prevail.
All right, so shall we move on to your third submission then?
My Lord, in relation to that, the tribunal is being approached behind the scenes, unilaterally, by one party in order to obtain some form of presidential imprimatur, stamp of approval, or whatever one likes to call it, on a way of giving proposed evidence. This is being done outside of standard procedure, which would be to call a CMR on the test cases in question and see what's...
All right, but can I be clear as to the context for this submission? Because this submission only becomes relevant if we are against you on your first two submissions, because if we're in your favour on either of your first two submissions, it's not necessary to address this one. So we therefore address this submission on the assumption that firstly, the FTT did have jurisdiction to receive video evidence from Pakistan. And secondly, the FTT was not misled by the Secretary of State. So upon those two assumptions, what is your legal objection to the liaison that appears to have been taken place with the President?
The objection is that one party is approaching the tribunal for approval as to the evidence that it proposes to put forward in relation to
But the
test.
President wasn't on the Constitution. So how is that relevant?
My Lord, the President was on the Constitution of one or two of a number of other cases.
Not this
But not this
I-
one.
I agree. The President sat on the on this case when it was due to be in front of him in January 2019 when it was adjourned. He didn't ultimately sit on this at the hearing in March 2020. But one has to ask oneself, what is it that the Secretary of State is hoping for in approaching the President behind the scenes in this way?
Yes, but I'm sorry. I don't think you're answering my question, because you are making a generalised complaint of impropriety. Let us assume, for the purposes of this debate, that indeed it was improper. The question is, what's the legal objection?
We have no idea as to how this may well have impacted upon the tribunal judiciary, because there is a real risk in relation to that. One has to ask, what was the aim of this liaison between the Secretary of State and the President? It was no doubt to obtain approval, which no doubt would have some relevance to a larger range of cases. We cannot be sure, we cannot take the risk that it did not, therefore, indirectly infect this particular hearing before this particular constitution. How is one? What is the purpose of this behind-the-scenes contact then, if it isn't to have an impact on?
Well,
on
one
the
way of
cases?
looking at it is to say that the Secretary of State was wanted to get a general steer about the sort of thing that the FTT would be looking at in the average case. What's wrong with that? But it's still the FTT's responsibility in each particular case to make its own decision about whether or not the evidence satisfies it.
Well, my lady, with great respect, I find it very hard to comprehend how a court could justify such conduct of one party approaching the President of the tribunal, who then has an impact on all, who is responsible for, has impacts on all other judges, or a steer.
But the President's not making a judicial decision. The President's being asked for general advice. I'm still not really following.
What is the purpose of him being asked in that way? Well, we
So
can't.
that the Secretary of State knows what is likely to be expected in general, and then can produce the evidence, and each FTT that hears a case can decide whether or not they're satisfied with the evidence, as I've already put to you.
And should that not be made known to everybody concerned that this is how the Secretary of State has conducted herself and pulled the President into such a discussion and improperly obtained such advice from the President, improperly, and then is using that steer in order to present the appeals.
I'm still struggling to understand how this arises in the context that we're looking at. So we have to assume for this purpose, as I said a moment ago, that the FTT has jurisdiction. We also have to assume that the FTT has not been relevantly misled. And they can then see for themselves the quality of the evidence. It doesn't purport to be consent. It doesn't even purport to be a request for consent. All it says is notification and no objection. And if that's inadequate, then the involvement in the President doesn't make it adequate. So what exactly is the problem that you are articulating?
That much is right, that if it's inadequate, the involvement of the President doesn't make it adequate. That much is right. But what has happened here, and one can paper over it, but frankly, it smells. What has happened here is that one party has approached the President of the Tribunal for legal advice as to what may constitute evidence in an important matter.
Put aside the anger for a moment. It's a perfectly legitimate view that it's not appropriate. There was a previous occasion when a previous Home Secretary sought to approach the Supreme Court, whereas the House of Lords then, for advice about what would be appropriate in terrorist cases, and Lord Bingham said, no, bring the case and do it. So I fully understand that this is not appropriate. But at the end of the day, firstly, the President, whether he was thinking about guidance, whether he was thinking about giving views on evidence, the President firstly didn't sit on this case in the First Tier Tribunal, but secondly, and in any event, there was an appeal to the Upper Tribunal. And whatever the views of the First Tier President of what would be acceptable in the First Tier Tribunal, the Upper Tribunal wouldn't have been in any way tainted by the view of the First Tier President in it coming to its decision that it thought the material was adequate. So I take it from a different view. I understand the view that it may be inappropriate for the executive to try and get help on the preparation of its evidence. There may be instances where it's appropriate to discuss things like practice directions and so on, and coronavirus hearings, what you do, and things. There are times it's appropriate. But assuming it's not appropriate here, I hate to say it, so what? Because he wasn't on this case, and we can't assume that two tribunal judges neglected their duty and pretended they were deciding it was adequate when there'd been some behind-the-scenes visit by the President saying, I've promised them this, you see me right, or you'll be in trouble, or whatever it is that you're suggesting. But in any event, when you get to the Upper Tribunal, they looked at it and they can't have been affected by what the lower tier tribunal president thought.
Firstly, so far as the FTT is concerned, all I'm saying is you cannot take the risk that the panel in this case were not infected by...
Oh, there's nothing to suggest they were. You've got two judges who take a judicial oath and they've heard argument and evidence. What's the risk?
My Lord,
that they neglect their judicial oath
my Lord,
and say to themselves, I know this isn't enough, but the President has promised the Home Office it is enough.
My Lord, the primary position, of course, is the evidence enough or not? Is it inadequate or not? As Lord Justice Arnold said, that's true. All I'm saying is that this context gives rise to a real cause for concern, so that it is difficult to see how the appearance that is then left should be allowed to stand. So far as
that's so far as the FTT is concerned. Then what about the Upper Tribunal?
So far as the Upper Tribunal is concerned, the Upper Tribunal is going on the basis of, is there an error of law in the FTT's decision or not? So we're really looking at the FTT's decision.
No, because the UT is, say that this was wrong, and say that the advice the Tribunal President was giving was wrong, and say he was leaning heavily on all of these members to say this, even though they didn't feel it. When you get to the Upper Tribunal, it's blown apart, because the Upper Tribunal looks at it, two experienced judges, they say, that's not enough.
But had we been told of this behind the scenes approach...
We'd have made a complaint. And so what? And we would still have given this evidence, and they still wouldn't have said it was a breach of Article 8.
And the upper tribunal would then have said, yes, on that basis, we think that there has been an irregularity, or there is a risk of irregularity, we'll send it back. But they weren't told that. This evidence only emerged, as your Lordship knows, at the start of this year, at the end of January this year, when it fell into our hands. My lord, that's essentially on the earlier parts. There's the unduly harsh elements, the ones of cross-references I may have to give.
Yes, indeed. Very good. Well, we'll hear you on ground 2 of the appeal at 2:05.
Yes, sir.
Mr. Kovats, you want to say something?
Yes, if I may, sorry, two matters which are completely separate. The one I'll deal with first relates to the point that you've just been canvassing with Mr. Gill. Over and above all the points that the court has been canvassing with Mr. Gill about that, I rise because I do have two concerns about this third element. One is, I hope not a pleading point, but it's difficult to see how it is spelled out from the grounds of appeal. The first two clearly are, but this, in substance, is a bias point, albeit in a rather unusual form, which simply doesn't feature. And the second point is relation to the facts. I'm not going to give evidence, but I clearly do have instructions from those sitting behind me. And can I put it this way? The evidence that you do have about what took place, can I say in relation to the President, deliberately neutral term, is by no means the full picture, and indeed I would go as far, if I need to, be so positively misleading as to what actually took place.
Well, you put the evidence in there, didn't you? It's your additional evidence.
It was
You wanted to put in a full
All
picture.
right, well,
Yeah.
yes.
suffice to say we've taken the health warning on board,
Yes.
and you can tell us more in due course.
The second point is in relation to the first two limbs of Mr. Gill's submission. In the course of the exchanges with the court, it's become clear to me that there are a couple of, three by my count, further documents by way of tribunal procedure rules, practice direction, and one case that may assist. Now, whether or not I get those emailed to you over lunch or take the view that we can deal with them tomorrow, I rise to ask for your guidance.
Well, see how you go. I'm not going to require you to do anything. You can exercise your professional judgment as to the best way forward.
All right, thank you. But at some point, I would like to email you on to it. If at some point I could get an email that would get them to your respective clerks.
Well, we will, of course, be assisted by anything you can provide us with.
Yeah.
Would you like us to ask one of the clerks to come in and give you an email address? Is that what you're asking for?
Yes, that's why I'm on.
Right, okay. Yes. Well, I'll try and do that because my clerk is on this floor.
Thank you.
Lord, we have those email addresses.
All right, I'll get it off
Clerks,
Mr.
and
Gill
so-
then.
Oh, right, okay, yeah.
Very
You've
good.
got- yes, because you must have, because you've emailed us. You must have it, yes.
Very good. 2:05.
All right.